We're on the record in case 24 CRI 163, caption State of Ohio versus Ryan Flickinger, here for purposes of bond setting on an indictment that was issued on May 10th of 2024. Defendant is present. We're conducting this hearing by video. Also present is Assistant Prosecuting Attorney Michael Callow on behalf of the state of Ohio. Mr. Flickinger, do you have any objection to the court conducting this hearing by video?
No.
Did you get a copy of the indictment?
Yes, I did.
Okay, court has to go over that with you. There's 2 counts and 2 specifications in the indictment. Count 1 is aggravated possession of drugs, a felony of the 5th degree. That reads on or about March 1st, 2024 in Ashland County, Ohio. Ryan Flickinger did knowingly obtain, possess, or use a controlled substance or controlled substance analog, and the drug involved in the violation is a compound, mixture, preparation, or substance included in Schedule 1 or 2, to wit, methamphetamine, a Schedule 2 drug, in violation of Revised Code 292511A, 292511C1A, aggravated possession of drugs, a felony of the 5th degree. And there's a specification that reads, the grand jurors further find and specify that the offense as stated in count 1 was committed while the said Ryan Flickinger is the owner and or possessor of a 2009 red Nissan VS VIN number 1N4AL21E79N424332, which was contraband and or property derived from or through the commission of the offense and or was an instrumentality the offender used or intended to use in the commission or facilitation of the offense, to wit, said vehicle being used to transport drugs and or drug proceeds, to wit, a trace amount of methamphetamine, a Schedule 2 drug. Do you understand what the state is alleging in count 1?
Yes, I do.
Okay, count 2 is possessing criminal tools, a misdemeanor of the 1st degree. That reads on or about March 1st, 2024 in Ashland County, Ohio. Ryan Flickinger did possess or have under the person's control any substance, device, instrument, or article, to wit, a 2009 red Nissan VS VIN number 1N4AL21E79N424332 with purpose to use it criminally in violation of Ohio Revised Code Section 292324A, 292324C, possessing criminal tools, a misdemeanor of the 1st degree, with a specification to count 2 that reads, the grand juror further find and specify that the offense as stated in count 2 was committed while the said Ryan Flickinger is the owner and or possessor of a 2009 red Nissan 4S VIN number 1N4AL2E79N424332, which was contraband and or property derived from or through the commission of the offense and or was an instrumentality the offender used or intended to use in the commission or facilitation of the offense, to said vehicle being used to transport drugs and or drug proceeds. Do you understand count 2 of the indictment?
Yes, I do.
All right. You have certain rights in this matter. First, you have the right to remain silent. Anything you say during the course of the hearing could be used against you at future hearings. You have the right to have an attorney, and you have the right to have a court-appointed attorney if you cannot afford to hire your own, and if you qualify. There is a $25 fee for court-appointed counsel. You also have the right to have a jury trial in this matter and to have the state prove your guilt as to the charges in the indictment beyond a reasonable doubt to all 12 jurors. Do you understand those rights as I've explained them to you?
Yes, I do.
Did you want to be represented by an attorney?
Yes, I do.
Can you afford to hire one, or did you want me to consider you for court appointment?
Court appointed, please.
Okay. All right. I have a few questions for you then here. All right. First of all, your date of birth. All right, and your address.
512 Ray Avenue, Ashland, Ohio, 44805.
Did you say Ray Avenue?
Yeah, so Ray Street. It could be Ray Street. I'm not sure.
Oh, Ray. Okay, gotcha. And do you have a phone number? All right, the last 4 of your social. All right, anybody else live with you at your address?
My girlfriend.
Is your nephew a minor
No, he's of age. He's 30, roughly 30, 32-ish.
or, okay, what's his first name again? Gotcha. All right, do you currently receive any state benefits like Ohio Works First, SSI, SSD, Medicaid, food stamps?
Medicaid.
Okay. All right, that does qualify you for court-appointed counsel then. All right, the court's going to appoint Attorney Anita Lambert to represent you. We'll let her know she's been appointed and she'll be at the next hearing for you.
Okay.
All right, we're going to address the matter of bond today also. Attorney Callow, the state's position on bond.
Judge, do you have our written bond recommendation?
Let me check the file here. Hang on a second.
Yes, ma'am.
Not in the file or on the docket, Attorney Callow.
Judge, this is Ryan Flickinger, right?
Flickinger, yeah.
Flickinger, yes, okay, sure. Yeah, BAT.
I have it for the next one, but not this one.
Okay. Yeah. Judge State of Ohio is requesting a surety bond of $25,000 cash deposit. Also a personal recognizance bond of the accused. Restrictions to stay in the state of Ohio. Also, a judge require the person do an alcohol or drug assessment, follow all treatment recommendations, secure the appointment in 14 days, report and confirm that with the court within 14 days. The nature and circumstances of the offense, judge, on March 2nd, 2024, APD Swaggart was on patrol at the Friendly Express gas station and observed Ryan Flickinger. Ryan was with two others. He then walked inside the gas station. Swaggart said hello to Ryan. As he left the store and asked who he was with Jason Poston and Alex Strickland. Earl Alex Strickland has active warrants. Ryan attempted to leave the parking lot quickly and Swaggart performed a traffic stop by the fin and feather and fur. In a vehicle search, a baled up piece of foil with white residue and glass bubble pipe was found. Ryan gave consent to search his phone where there were messages between Ryan and Tommy Norris, where Ryan was trying to sell Tommy a ball of meth, which he advised was Earl's meth. Earl admitted the meth pipe was his. He admitted he had used it earlier that day. Ryan admitted there would be paraphernalia and a small amount of meth at his house and gave consent to search the house. The car was towed. Jason admitted a used syringe had fallen out of his pants onto the floorboard of the cruiser when he was in the back of the cruiser, and then he panicked during a traffic stop and put it in his pants. Earl had $1,002 cash in his person and was believed to be on the way to buy drugs. At Ryan's house, a meth pipe with residue, crystal substance in a plastic drawer, digital scale covered in meth residue, and a used syringe and cut straw were located. The weight of the evidence, judge, is strong. The identification of the defendant was confirmed at the scene by law enforcement. Defendant is a resident of Ashland County. Per his CCH, he has a 2009 theft, criminal damaging, 2009 theft without consent, criminal damaging, possession of drugs, possession drug abuse instruments, theft without consent. Richland County 2010 possession of drugs, Ashland 2010 possession of drugs, Ashland 2011 breaking and entering, Ashland 2014 possession of drugs, Richland 2016 theft, Richland 2017 petty theft, Richland 2017 theft, Ashland 2018 domestic violence, Ashland 2018 possession of marijuana, Ontario 2019 petty theft, Ashland 2020 possession of cocaine. Judge, the co-defendants in this case are Jason posting. And Earl Strickland, we asked that both bonds can include a no contact order. Thank you, Judge.
All right, thank you. Mr. Flickinger, if there's anything you'd like to say regarding bond, the court can't decide the facts today. You can say so right now.
Okay.
I'll just remind you, you don't have to because you have the right to remain silent. So if you want to talk to your attorney first, that's fine. Sir?
No, I would like to say something.
Okay, go ahead.
So back in October, my mother died. I've been trying to get the car and the house, all through probate court and into my name. It was all left to me. I got maybe $300-400, to my name right now. I don't know. I mean, I heard what the recommendation was, which was way more than what I can afford. If the court could somehow cut me a break with that, that would be greatly appreciated, so I could go through and, get the house and get the car all the way into my name and everything, and I don't lose it all.
All right, thanks you, sir. All right, the court's going to set bond as follows. To be released, you'll have to post 2 bonds. The first is a personal recognizance bond. That's your written promise with the court to appear at all future hearings in the case.
Okay,
Fail to appear and violate that bond, you can be charged with another felony offense for failing to appear. The second would be
understood.
either a bail bond secured by the deposit of 10% of the amount of bond in cash, or a surety bond or a bond secured by real estate. The amount of it would be $7,500. As conditions, you're ordered not to leave the state of Ohio without obtaining written permission from the court. Appear at all future hearings in the case. Keep the court informed of your current address and telephone number at all times. Follow and obey all laws of the state of Ohio and orders of the court. Do not use, consume, or possess any drugs of abuse or alcohol and be subject to random drug and alcohol testing. Cannot use any product containing THC while you're on bond. You also have to seek a drug and alcohol assessment from a properly credentialed treatment professional and comply with their recommended treatment plan. You need to make that appointment and provide verification of the appointment to the court within 14 days of posting bond. After you,
I'm sorry. So that's 7,500.
yes, with a 10% posting. After
Okay.
you post bond, you need to report to the court's bailiffs, whose office is located across the hallway from the clerk of courts. They'll get you signed up for the court's drug testing and bond program. Court's going to also order you have no contact with Jason Poston or Earl Strickland.
Okay.
The bond. Do you have any other questions about bond?
Oh, what would 10% of 7,000?
$750 would be 10%. Okay.
Any way we could drop that like $200?
The court can always readdress bond. We're going to set another hearing, so talk to your attorney about that.
Okay.
That hearing.
Okay.
All right, Wednesday, let me see. We do Wednesday, May 15th at 10 a.m., Attorney Callow. Oh, you're on mute. You're on mute, Attorney Callow.
Sorry, Judge. I said I'm not available in the morning. Can we do the afternoon? No, we've got a 1:30 and a 2 o'clock. Can you
Okay.
post us around those two somewhere?
I can do 2:30. All right. Mr. Flickinger, if you bond out, your next hearing is going to be 2:30 on Wednesday, the 15th. You bond out, come to the courthouse for that. If you don't bond, we'll have you by video again, but we'll give you a chance to talk to your attorney privately before we get started.
Okay.
Any questions on anything?
No.
All right, we'll see you back on Wednesday then. We're adjourned.
Thank you.